Before we dive into today's episode, I want to let you know about an incredible CLE opportunity coming up in just a few weeks. On Friday, February the 18th, the North Carolina Advocates for Justice is hosting a CLE on handling expert witnesses in North Carolina impaired driving cases. Program chair Chaz Post, who is a close friend, we went to law school together. He was the first attorney guest on the podcast back on episode 6, has put together an incredible group of presenters, both attorneys and expert witnesses. Ron Shook is going to talk about the history of Rule 702 and tendering your expert witness. Ron was on the podcast, also a good friend, back on episode 38. Justin Hunter is presenting on cross-examination of the state's expert witness. And then we've got a group discussion that is going to be moderated by Kelly Dawkins and Anna Smith-Feltz. So a great group of attorney presenters. We also have a couple of expert witnesses that will be presenting at the CLE. Doug Scott, who was on our podcast back on episodes 12 and 13, he's going to be talking about his role as an expert and presenting on expert testimony for standardized field sobriety testing. So Doug's been doing this forever. You're going to get a lot out of that presentation. And then Dr. Andy Evans, who is on the podcast back on episodes 59 and 60, is going to be doing a presentation on attacking the ECIR2. So what more important expert could you have than somebody that is going to guide us through that process, as well as Doug through the standardized field sobriety testing? I mean, obviously key issues in pretty much every DWI case. So you get to end the day. This is a virtual only CLE. Originally it was going to be in person, but they've modified it to virtual. The bad news is we don't get to hang out together. The good news is that there's no excuse for not coming. If you can't make this CLE, it can't be an excuse that, oh, I've got too far to drive or I don't have time. Join the CLE and get as much as you can out of this kind of great group of presenters. But you have to end the day by listening to me talk about ethical marketing. So I will keep things lively and energetic so that I don't have people falling asleep late on a Friday afternoon or leaving the CLE before it's over. So I'll do my best on that front to keep everybody entertained. Again, if you make this happen, please join. For members, the rate for the CLE is $290. For non-members, you should get signed up for the North Carolina Advocates for Justice. So if you're not a member, you should be, but for non-members, it's $390. Go to go to ncaj.com, go to the education tab and sign up for the event on Friday, February 18th. Look forward to seeing you there.
Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 94 of the NCDWI Guide podcast. On today's episode, we have DWI master Marcus Hill on the podcast. Marcus Hill in the house. Marcus is an incredible communicator. I first discovered Marcus at a CLE many years ago, and his talk was chock full of very helpful and practical tips on how to better try a DWI case. And I took a lot of those practice tips and immediately incorporated them into my own practice. I've stole motions from Marcus's website. I go constantly to his website. He's got a case list on his website that is just incredible. Please check out his website, marcushillattorney.com, and look at his case list in the drop-down bar. It is an incredible resource. We referenced that resource back on episode 53 of the podcast when we talked about 10 incredible resources for NCDWI attorneys. Marcus Hill's case list was one of those resources. He also on his website, he's got all kinds of great information. It's a lot of it is really designed for attorneys, but he's got a great page on his website called Successful Arguments, My War Stories. And it's just really a beautiful narrative section of how Marcus's storytelling abilities of his cases come out. So go check out that. Marcus has been practicing in criminal and DWI defense for over 30 years. He spends many hours each month researching the latest cases, legal treaties, scientific literature, and articles on the subject of drunk driving defense, allowing him to be on the cutting edge of DWI defense at all times. The reason that I think that Marcus Hill is a master of DWI is not only does he have a grasp of the law, he's constantly trying to elevate his knowledge of DWI. And you'll hear that during our conversation. But Marcus has taken that knowledge, that really foundational but very deep knowledge, and used that to allow him to create nuanced ways of arguing very specific DWI topics. Because of his deep, deep knowledge of these issues, Marcus is one of the most creative brains that I have ever engaged with in the subject area of DWI defense. There's this ability to draw from all of his past experience, cases, scientific literature. That's what's allowed him to then have these very, I think, creative and nuanced, but very good arguments. Marcus is not interested in throwing up something that's not going to work. It's about how can I practically do a great job trying a district court case, and he is a master of that. Very excited to have Marcus on the podcast, and I hope you enjoy today's episode. Maybe a great place to start would be to just kind of get a little background about kind of how you began practicing law and why you chose to kind of focus in on DWI cases.
Okay, I can do that. So I decided that I wanted to be a lawyer, just what I do today, when I was 6. I don't remember that independently.
That's crazy.
My mother would tell this story over and over again about me walking around with a big old law book that was probably bigger than I was, and she would look at me and go, "What are you doing?" And I said, "I'm a lawyer." Now I didn't know what that meant. Anyway, I thought my dad did this kind of practice, and he didn't. At least not exclusively, but I decided I wanted to be him, basically, because he awesome. Came home every day with stories to tell and had met new people and had interesting times and got to be a hero. I think one of the great things about being a lawyer that I think a lot of us don't notice is that we get the chance to be a hero often. And I say, if you get the chance to be a hero, you should take that.
That's awesome.
And so my dad did that every day. I talked to Anna Cole, who you may know is one of the clerks in the courthouse, but was dad's secretary for many, many years. And she said he never turned down a person because they didn't have money. He never didn't represent someone that came and asked him to represent him. I can't say I'd do that because I got to make money to eat, but I always loved the practice of law because my father loved it. And he was my hero and my idol. And he told us every day how lucky he was to do it. He was grateful to do it. He was a lawyer in the time where you weren't just a lawyer for work. That's what he was. And so when people called on Sunday afternoon after we came home from church, he would answer the phone and be gracious. And I would be angry at him because I wanted to spend some time with him. And he'd say, but these are my people and I have to take care of them. In the same way, if my father, when he was growing up, if he needed a rake on Sunday, he'd have called the guy that owned the hardware store, and the guy that owned the hardware store would have met him at the hardware store and sold him a rake. Imagine, if you will, calling Home Depot and asking them to meet you on a day off, on a day they're closed, to sell you a rake. They wouldn't do that. But the guy that owned the hardware store was the hardware store. That wasn't just what he did. That's what he was. And that's what my father was a lawyer all the time. And I have decided not to do that because I don't think that's healthy. But he really enjoyed that. He really loved that. And he felt fulfilled in his life. As he was retiring, I told him he would die. And he said, yep, and I'm ready for it. I've had a great life. I've enjoyed it completely. I'm not as smart as I used to be. I hurt when I get up, and your mother bitches at me all day. I'm ready to go. Now, I'm not going to make it happen, but I'm ready
he
to go
must
when
have
it
gone pretty late into the career, because I had the fortunate experience of being able to be a new lawyer and meet your dad while he was still practicing, and he was just such a great character, always the best dressed in the courtroom. You'd see him walking down the street. I think he always walked back and forth from his office to the courthouse, and just always a smile on his face, always a joke to tell. He seemed to really love what he did. And so that was inspiring, because it's like, here's a guy that has been doing this, and I didn't really know it at the time, but how long did he practice? About 50 years, or what was
over 60 years?
I mean, that's wild. I mean, but just seemed to still really enjoy it. It wasn't like, this was a chore to him. So that was, as a new lawyer, it was one of those things where you constantly encounter people that are kind of burned out from the practice of law, and the stresses and everything that comes along with it. But then here was Edison, who was ready to tell a joke, and just this friendly face in the courtroom, but also very keen on trying to get a good outcome for his client. And so it's just a real blessing to be able to see that from somebody that had been doing it for such a long period of time.
Well, and I think that's one of the things that we forget as lawyers sometimes, is that we have to have a good life. I think I'm not a very good lawyer when I'm stressed and burnt out and
Correct.
angry. And I get that way like everybody else. But if I take some time, mark off some time for myself. So when I take off my suit and tie and go home and go play volleyball or play poker or go out with my friends, I'm not a lawyer. And if people come up to me and ask me lawyer questions, my partner or my friends will look at them like, he's not working now. So do not ask him lawyer questions now. Here's his card. You can call him the next time the office is open. He'll be glad to help you, but he needs some time off. And I think my father didn't need that, kind of for reasons of the society that he grew up in, but I do. And I think we all do. And I wish that all lawyers would take a little time and maybe understand that, whatever the stressor is today isn't going to be a long-term problem. I remember those problems that I've lost sleep over the course of I've been practicing for over 30 years. None of those things are still here. None of those things are a problem. None of those things are really bothering me today. And I should have not worried about them, because I noticed the difference was when I worried about them, I didn't sleep well and I felt worse. They didn't change. They were still the same problem. I just didn't have as good a life. So I decided my best mentor for that is my dog, Penny, who never worries, is never afraid, is never worried about whether rent's going to be due. Or she's like, we got a ball, we got a yard, we're in great shape.
It's one of those things where I feel like, whenever you think about going on a vacation or maybe to a CLE or whatever is kind of out of the ordinary time of just being day to day, answering the phones, running to court, there's that, constant almost inability to disconnect and want to answer that phone, want to be in there. But it's like whatever fires were present when you left the office, they'll still be there when you get back. You don't have to worry about them going anywhere. They'll still be there, but you got to take that break when you need it.
You do. You need to have a life outside of the practice of law, because that makes you a better lawyer. That makes you a fuller functioning person. That makes me a better lawyer. I'm not a good lawyer when I'm angry or tired or sick. And those things you forget in the midst of, but this guy, if I don't talk to this guy, he'll be angry, or I won't get this case, or this thing won't happen. And I think I have made pretty bright lines about where I will, do my work and where I will not be doing work. And I try to let people know that. And some people don't like that. If you look at my Google reviews, there's a guy who called me on Saturday. I didn't know him. He'd never talked to me before. And I answered the phone and he said, I need a lawyer. And I said, is your case set Monday? And he said, no. And I said, well, I don't generally work on the weekends. I mean, if it's some emergency. He said, well, it's really an emergency. And I thought about it for a minute and I said, I can't be a lawyer right now because I have life obligations that are more important than that to me. He wrote me a really bad review and essentially implied that if you have your phone number in the phone book or in Google, then you must answer it at all times and deal with whatever occasions, whatever emergencies have arisen. I don't think that's the way I want to practice law. Once again, some people do that and good for them. I don't think you can do that for a long term. And the heartening thing to me is I've been doing this 30 years and I still look forward to coming to work during the day. I look forward to meeting my clients and getting a result for them, and the intellectual battle it is with the district attorneys and judges and police. But you asked me why I picked DWI. So I wanted to tell you the story of how I got my first lawyer job. So I was making lots of money selling stereo equipment when I graduated from law school. And I wanted to, I love that job. It was great. I was, hanging out with rich people selling very expensive equipment that made them very happy. And I enjoyed selling it, and I'm good at selling things. And so I decided, though, that I've spent all this time and effort going to law school, taking the bar. So I needed to, get out there. So what I did was I decided to, once again, we're going to talk about this in a minute, but my philosophy is do the last thing first. So I thought about what I wanted to be doing a decade from that day. And from the perspective of a young person, it's awfully hard to look forward a decade, but I wanted to figure out who I was a decade from that day. And then I'll work backwards towards the beginning of it. So what I did was I did a bunch of research and talked to a whole lot of lawyers about who did small criminal work, DWIs, traffic cases, misdemeanor stuff, what we call district court stuff, because I felt like those were just regular people. That's your mother and my friend and the guy you met in the street, and the bartender and the taxi driver. Those are those people. There are some people who are seriously evil, even in that realm, but not that many. As you get higher in the criminal realm, you get into people that have done truly evil things that are hard to deal with, like, people who abuse children sexually and people who kill each other. I'm not saying those people don't deserve defense, but I was hoping to work for more of the people that I know and not this outlier crowd of people that are, spend a lot of time in prison. I talked to a guy once, he said, I'm doing life on the installment plan, 5 years at a time. So he would do 5 years, get out, he'd have some fun during his time out, and then he'd get arrested again, go back to jail. I didn't want to work for those people. So, and I also wanted to find an area of law where you could actually try cases, because I really enjoy trying cases. That sitting down and, standing up and saying not guilty and sitting down, and that intellectual challenge and that thrill of the trial is something I love. And I love it in district court. I don't like it in superior court because seems like there's a lot less control. I mean, there's 12 people here and they went home last night and something happened to them I don't know about. This is a judge that I know, a DA that I'm comfortable with, a cop that I've talked to before. And that makes me feel like I can manage the workload so that I can do a good job for my client in a way that in superior court, I think you've got a lot more variables and a lot more difficult.
I totally agree. I think that that's definitely one of the reasons to me district court criminal practice is so much fun, because you do get to kind of help the everyday person and a lot of great people, like you said, that for the kind of higher serious felonies. I've kind of always taken that same position. I would always joke early in practice with my legal assistant at the time that, hey, are we going to get that murder call? And it was always a joke because we're never going to get a murder call. But even if we had, I wouldn't have taken it, because that wasn't what I was interested in doing. It was kind of helping the everyday person that is dealing with these, pretty major stressors in their life. But like you said as well, this ability to try cases and to do it frequently is so amazing in terms of the DWI spectrum. That's just such an easy place to get into the courtroom in front of a judge and argue real legal issues.
That's right. And there's no deficit to it. So if you're doing federal criminal practice, you are not going to try cases. And the reason you can't try cases is because they're going to offer you a plea that you almost certainly have to take. Because if you try it and lose, there's such a dramatic draconian penalty that you just can't do that. Whereas with DWI, here's what the DAs offer you. As you know, you can plead guilty as charged, or you can plead not guilty. That's our plea offer.
That's right.
So what's the downside to plead? There's a downside to plead not guilty. And I don't think you should do that on a case where there's no argument. I think you lose credibility if you do that. But in a lot of cases, there's an argument. Maybe you won't win, but maybe you will. And you sometimes discover things on the way through the trial that help. And I think that's a great blessing of DWIs in small criminal cases, because there's not that horrendous penalty at the end that makes you required to enter a plea. And I don't mind entering pleas, and I enter pleas. I'm just saying what my favorite thing to do in the world with my clothes on is sit down at a table and try DWI in district court, because I feel like I know what I'm doing. I feel like I'm good at it, and I enjoy the constant intellectual challenge of it.
Yeah, that's
when I picked DWIs, I did some research and found out who did the most DWIs in Durham. I picked Durham because I wanted to live here, and I looked around and I asked a bunch of lawyers, and they told me about a lawyer, Jerry Clayton, who I worked for. And so then I managed to wangle an introduction to Jerry's associate, Bob McClanahan, who did his domestic work. Because in interviewing all those lawyers, I asked them, if you had a young lawyer come to your office and offer to help you with work, what sort of work would you want help with? And almost all of them said domestic, child support, custody, those things, because those are important cases. They take a lot of time. We don't like them because usually clients are unhappy, and there's a long run-up process to getting to the hearing. It's just a pain.
It's a pain.
We really love a young lawyer to do that. And so I talked to Bob McClanahan and asked him if he wanted someone to assist him with domestic work, and he said yes. And so I said, when Jerry calls you down to his office and asks you if you need help, tell him yes. And he said, yeah. So I went to Jerry's office. I showed up. I only had 2 suits. I showed up at Jerry's office one Monday morning in my best suit, sat there all day. He wouldn't talk to me. I went up to the desk and they said, can we help you? I said, yes, I need to see Jerry Clayton. And they said, do you have a criminal charge? I said, no, you're going to hire me. And they said, we're not hiring. I said, well, yeah, nobody else is going to apply, but you're going to hire me. So as soon as you let me talk to Jerry, he's going to hire me. And they wouldn't let me see him. I sat there all day, came back the next day in my other suit, didn't see him, came back Wednesday in the coat to one, the pants to the other. I only had 2 suits, so I had to do something. And eventually, I think the young ladies at the front desk got tired of seeing me sitting there and went back and said, you need to tell this kid we're not hiring, so he'll leave. And he called me back.
The squeaky wheel. I love it.
I'm telling you. And he called me back there and he said, what's this about? I said, you're going to hire me today. And he said, no, I'm not. I'm not hiring. I said, yeah, you are. You're hiring me. You just didn't know that until right now. Let me tell you why you're going to hire me. And I told him what I was going to do. And I told him to call Bob McClanahan to his office. And if Bob said that he didn't need help, I would leave and I would apologize for taking his time. And if Bob needed help, just think of all the time, money, and effort I saved him in finding a good lawyer to do the work that he had done that he didn't even know about. And so Bob came down and said what we'd agreed he would say, and he hired me that day. And so I think what I did was I made up a job as opposed to applied for a job. So I made up the job I wanted, and the job I wanted wasn't domestic work. But what I figured was I was smart enough to get good at domestic work, and then I would weasel my way into the traffic and criminal practice. And then eventually I'd come to Jerry and say, you got to hire somebody to do the domestic work because I'm too important in your criminal practice, which is what happened. And we hired other lawyers for the domestic job that I made up. And then I began to organize the criminal practice for Jerry. I started that at the very beginning because that's what I wanted to do. But once again, that's how I think the way to get a job that you love is to make up the job you want and then figure out how to apply for it. And that's what I did.
Yeah, that's wild. I mean, in terms of that background in sales came in handy because coming in like that was quite the move.
It is. Well, it worked out. And like I say, it was part of a long distance plan. So I want to tell you about my general approach to life and
I love that beginning with the end in mind. And I think it's so important for young people listening to this, because I think it's easy, whether you're working in a firm or you have your own firm that you're running kind of early on, it's so easy to just kind of be worried about tomorrow. And sometimes that's pretty necessary to just be worrying about either today or tomorrow, but to have that 10-year plan is really important. I mean, what is the long-term reason why my law practice is supporting the rest of my life? And, what do I want to focus on? How do I want to help the community long-term? Those kind of, bigger picture questions are really important early on in practice. So I love beginning with the end in mind. So wherever you want to run with that.
Well, I call it do the last thing first. And so
Okay.
when a client comes into my office and they have a DWI, and I talk to them about the case, I get all the paperwork, they sign the agreements, and they pay me the money. What's the very first thing I do in beginning my preparation for that DWI? And the answer is I write my closing argument to the jury that day. Now, I don't actually write down my closing argument, but I have a sheet in the back of the file in which I write out what I think I'm looking for. And then what I can do is I can work backward from that closing argument to where I am today. And that way I won't waste a lot of time. A lot of lawyers come to me and say, what should I do with this case? And they hand me the shuck. And the first thing almost always is, you should have been ready before today, because today's the court date and that's too late to be ready. You got to prepare before that. But what a lot of young lawyers do is they take in a case and then they just start doing stuff that they think they're supposed to do or they ought to do or whatever. And none of it leads to that final argument. So I tell people a story about driving to Los Angeles. If you want to go to Los Angeles and you need to be there Thursday a week from Thursday, then you can just get on 40's mostly west and drive, and you'll end up in California or Washington or Mexico. But I mean, you'll be west. Or what you can do is you can start in LA on Thursday and say, I'll be staying at this hotel in LA on Thursday. And then on Wednesday, I will stop in Las Vegas and stay at this hotel. And on Tuesday, I'll stop in Arizona and this hotel. And then you want to build in a couple of days in case you run into traffic or your car breaks down. But if you do that, then you'll certainly be in LA on the day you're supposed to be there, because you made the plan. My plan is to be in LA on this particular day. And then you go backwards from there to get to the route. I think that's a much more effective route. And when you're doing that with the case, you want to look at what cases do I need? What sort of arguments might I make? There's a lot of evidence, as you know, in DWIs that goes away if you don't preserve it. And so you need to begin preserving that evidence by figuring out this is going to be important at the end of the case. If you realize that it isn't important, then you probably shouldn't waste the time doing that. And there's other things you can be doing. And so I think you ought to do the very last thing first. The last thing I do in a case is make my closing argument to a jury. So I want to start with that. And of course, then I'll talk to the police officer and there'll be some other things and I'll change my closing argument. But I'm always looking at that last step. And most of my cases, I only stay in district court. So you might say, well, why are you writing your closing argument to the jury? Well, I'm really writing my closing argument to the district court judge, but that'll also be the closing argument I make to the jury as long as it works. So it gets me there in a much more effective way, and I don't waste a lot of time doing silly things.
I love doing it in that narrative format, because the closing argument is almost always some sort of a story. So kind of, thinking about the case in that story format from the get-go, I think really does give a competitive edge in terms of how am I going to present this case, instead of it just being these kind of disconnected pieces of evidence, by putting it into that narrative form. And you've got, I don't know if this is kind of from that, collection of closing arguments, but you've got a page on your website devoted to my war stories. And you have a whole laundry list of just kind of incredible stories in there that are you're a great storyteller. I mean, you can tell that from how these things are written. So if you kind of, anybody listening that wants to go kind of see what some of these stories may look like, Marcus has, and I'll include in the notes a link to this particular page on Marcus's website. You have this just like great story format on your website, sharing with other lawyers some of these stories that you've used. So I love that kind of narrative element of things.
I think every trial is a story. Everybody says that. So how does that work in terms of what you do to prepare for a trial and how you present evidence? And I think you need to ignore the stuff that doesn't matter. I'm reminded of a great lawyer now dead. Kirk Osborne used to be the public defender in Orange County. And I noticed Kirk would always take 2 or 3 hours to do a 30-minute case. And it drove the judges crazy. And I don't think you keep a judge's attention for that long, really. I don't think they're paying attention. So one of the judges, who will remain unnamed, who was really upset about Kirk for doing this, I was sitting there waiting for my trial and realizing I'm probably not going to get reached today because Kirk's going to take 3 hours to do it. and getting a little aggravated. And then I started watching the judge, and the judge was reading a newspaper. And for people who don't know, the bench the judge sits on usually has a lip. So you can read a paperback book without people seeing you turning the pages. He wasn't reading a book. He's reading a newspaper. And I swear he went through that newspaper 5 or 6 times. What he would do is he would turn the pages and then he'd put his finger down. And if somebody said something, he would stop, obviously not paying attention. Then he'd look over and say, "What did you say?" And they'd say, and then he'd make a ruling, and then he'd pick his finger back up and begin reading the paper again. Over and over again. And finally, when we came to the long delayed closing of the case, Mr. Osborne made his closing. Took him a long time, and the judge was continuously reading this newspaper over and over while he's making the closing. And then when he finished, he put his finger down. He said, "Anything else, Mr. Osborne?" "No, sir." And the DA stood up and he said, "Sit down. I'm finding him guilty." And this was an object lesson that you've only got so much attention, and you want to decide which arguments you're going to make. You don't want to spend a lot of time on an argument that's silly, because you're going to lose the judge's focus. And I think that's true of every person, is you lose their focus if you don't limit it. So I try to do fast trials. My trials don't last that long generally. Sometimes the DA will drone on and on and on and on. And one of the bad things is that when the DA does that, the judge loses focus, and I haven't even had a chance to talk. I mean, I said not guilty. That's the only thing I've said. Yeah. And that makes it frustrating. So sometimes you have to be a little, you have to throw in a little drama. So I was trying a case in Durham one day, and a judge who was presiding had lost focus, and I was paying attention to other things and wasn't paying attention to that. My client pulled on my sleeve and said, "The judge has left." And I went, "Oh shit." And I looked up there. No, she was still sitting there. She was gone. She was completely gone. She wasn't paying any attention. She was fiddling on her phone. She was, nothing was affecting her in that courtroom at all. So what I did was I knocked over the water pitcher, and I didn't just tip it over. I splashed it. It went about 15 feet, hit the floor. The bailiff jumped up and pulled a gun. But by God, she was paying attention for the rest of that trial. I was saying, she didn't look away not a second for the rest of that trial, because I thought she was about to have a heart attack when all this happened. I lost that trial, but by golly, she paid attention to my argument. So sometimes you have to do something dramatic or make some keep people's attention.
Yeah. And I think that telling the case through the form of a narrative is so much more compelling to anybody, whether it's a judge or a jury, for that reason, because of attention span, but also for your client. Because I think if we focus on the field sobriety test and these particular clues and the HGN and the number, and we make it about the facts of the case, what do a lot of people say when they go to trial? Well, I want to have a chance I want to have my day in court. I want to have a chance to tell my story. So if you're helping present that story, I think that actually helps the client feel heard as well, as opposed to it just being about what the officer did wrong or kind of these kind of disconnected, nitpicky things, even though sometimes that can be important. And I'm not saying you don't want to go after the officer on that front, but at the end of the day, in closing, if you can encapsulate something that is redeeming about your client, or the reason that this happened, or how the kind of facts played out based on what was going on earlier in the day or connected to this particular client's life, you're giving them that opportunity to have their story heard. And I think that actually is something that is valuable to the client, win, lose, or draw.
It is. And it makes them feel like they got their day in court. And like you say, the one thing that clients have said to me routinely throughout my career is, I just want them to know something about me. I want to be heard in this case. And as I do, that we rarely put our clients on to testify. I do sometimes, and I'm okay with doing that. And I make sure I always ask them, because what I found is sometimes they'd rather lose the case and testify than win the case and not testify. So
that's right. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.